Welcome everybody to today's Lunch and Learn regarding blended families. I am Laura Brancato, a senior attorney with the law firm of Littman Krooks, and I work primarily in the elder law and litigation unit in the office. And today we're going to be talking about the impact that blended families have on the potential for litigation and what are strategic ways you can avoid potential litigation through proper use of estate planning and estate planning documents. So first, it's important to define what a blended family is. Certainly, there is no one definition for blended family, but blended family is commonly referred to as a family where there are children from previous marriages or previous relationships, and those two families are combining to form a new family. There are various names. Some people call, stepchildren or step families or reconstituted families. This can be individuals who have remarried or just living a committed lifestyle together. Either they have no children in common, so they each bring children from their previous relationship, or they have previous children and also then have children in common. And what are the different ways that we can defensively plan to make sure that conflict doesn't arise down the road? So once we understand the definition of blended family, it's important to understand what is proper estate planning generally. Now, at Littman Krooks, we do a lot of work in the estate planning field. We have a very robust estate planning division, and our website has plenty of information about what estate planning should look like. I'm going to give a brief overview today, but if you should need additional information, you can always find it on our website, littmankrooks.com. So generally, from an estate planning perspective, we would like clients to have advance directives and either a will or trust in place. And advance directives commonly include power of attorney, living will, healthcare proxy, and can include other documents like a nomination of guardian, which we'll talk about a little bit later. And if the estate plan is done well, the documents should be properly executed and should be kept in original format by the person named in the documents. So specifically what this means is that the provision of an attorney or other knowledgeable person should be involved in your estate planning. Estate planning documents which are not properly executed are useless. And so if you have a complicated family arrangement, using an online will provider or informal services to do estate planning is probably not in your best interest. You should rely upon the expertise of lawyers who specialize in this type of planning. And you should be sure that you have as many advance directives in place as apply to your particular circumstances, and should be sure that the documents have been executed properly and that you maintain original copies of all of those documents in a safe place. And that's because documents, especially a will, which cannot be located in its original form, are not valid. So if your original will cannot be located after your death, it cannot be probated. Similarly, it's important to consider the use of a will or a trust instrument because in New York, if you pass away without a will, regardless of how you would have wanted your property to pass, there are certain rules of administration that will determine how your property gets distributed. And this could mean that your blended family won't be treated equally. If your stepchildren are like children to you, if you have not legally adopted them, they would not receive under the rules of administration in New York. So it's essential for blended families to have proper estate planning in place to assure that their wishes are honored when they pass away. It's also crucially important to make sure you have up-to-date and properly executed advance directives. It's far more likely during your lifetime that you will need help while you're still living. And we do encounter a great amount of frustration and really just an inability to act unless a client has properly executed advance directives. So where do conflicts arise? Where, as litigators and at Littman Krooks, do we see conflicts arise? And it can come in a number of formats. I think most commonly understood, people think of a will contest. What happens when I pass away if people do not agree with how I have devised my assets? That a will contest can ensue. That can happen to anyone of any family structure. It can happen to unmarried people, even who have no children. However, it is more common to occur in a scenario where we have blended families and where individuals may believe they're entitled to a share of your estate if you do not have previously written instructions. We also see litigation, though, and much more recently, while during lifetime, either through a proceeding called a guardianship, which is pursuant to the mental hygiene law of New York, or even through litigation over your power of attorney, which is promulgated pursuant to the general obligations law. So, what I mean by this is that we are seeing as practitioners a great uptick in the number of conflicts that are arising among family members while their loved one is still living. And that's actually, in a sense, far more of a challenging circumstance because you will have to live through the conflict among your own family. So, whereas in estate litigation, litigation would ensue after your death, in different types of litigation during your lifetime, like the two I just mentioned, you might be caught in the middle of individuals arguing over your assets. It's also possible and very likely that those proceedings in the mental hygiene law or in general obligations law, guardianships or power of attorney litigation, those are going to be initiated in all likelihood if you lose capacity. And what we mean by that is if you lose the decision making ability because of the onset of a cognitive impairment. So often we see this in an Alzheimer's dementia scenario where a client has advancing Alzheimer's or dementia, and they no longer are capable of making decisions, financial or medical, on their own. In those circumstances, without well drafted advanced directives, it is very easy for families to get engaged in a very expensive and lengthy Supreme Court battle over who should be making financial and medical decisions for you. And those guardianship proceedings and power of attorney proceedings can be very contentious and very expensive and often can be avoided with proper estate planning. So we're going to go through what some of those documents look like and how you can best address the potential for conflict while you're still healthy and while you're still alive. So our number one recommendation to families, especially blended families, is to communicate. Now, it's important to understand that your estate plan, when you create one with an attorney, is confidential. If you meet with a lawyer and determine that you would not like to disclose any of your estate plan, the lawyer is bound by confidentiality, and the documents and the plan can only be disclosed to the parties that you determine should have access. That said, conflict certainly arises when clients create a plan and don't communicate at all about that plan with their family while they're still capable. So, what I mean by this is that oftentimes, and this is true of all of our clients, having discussions about illness or end of life, those are challenging circumstances to begin with. Most clients find discussing end of life choices, let's say whether to be fed or maintained on medical equipment, those discussions are difficult. However, when in a blended family, especially, there are not clear expectations, even among the new spouses, the spouses who are coming together to create the new family, even when there are not really well thought out discussions among those parties, the conflict can arise very easily. So, setting expectations or having conversations to the extent possible or to the extent you're comfortable with can alleviate the concern of somebody being surprised at how assets are being left or how they're being even managed during your lifetime. So, for example, take a set of clients, a husband and wife, who both come into a second marriage later in life. They each have their own children. The wife has two daughters. The husband has two sons. Since they married later in life, their children are not particularly close. The parents live in Westchester. The children live all over the country. The husband and wife come into the marriage each with their own assets. the wife having owned a condominium and some other retirement accounts, the husband having owned his own apartment and some of his own investment accounts. That type of couple who then get married and maybe buy a vacation home together or commingle their assets into joint investment accounts, that type of arrangement, especially where the family is not particularly close to one another, the children have really no relationship with each other, that's something where if the parents are going to make a plan other than to leave everything equally, the wife leaving all of her previously obtained assets directly to her daughters and a 50% share of the joint assets to her children, the husband leaving a similar pattern, absent something that's very equal on its face, there is a potential for conflict. And depending on when the plan is disclosed, the conflict can arise during your lifetime through, let's say, a guardianship proceeding, or it can certainly arise after death with a probate proceeding, if that were to be the case. So the communication of desires and even the basis for why assets are being left in a particular way always can put everybody on equal footing and can be used as later evidence of your intent, that you intended to treat children unequally, that it wasn't an accident that one child got 30% more than another, and the reasons why. And that's also something you would communicate with the person drafting the documents, so the file could be maintained and all of your intentions could be recorded and be useful later in litigation. So aside from communication, one of the other ways to try to alleviate feelings of mistrust or of strife would be to include individuals from both sides. And I use the word sides only for illustrative purposes, not that everyone automatically comes in arguing, but to use children from both relationships together. Or often we see this in a scenario where we have a second spouse who is at odds with the children of her partner's first relationship. So if you appoint in your advance directives not only your new spouse as power of attorney, but maybe one of your children, as long as they don't already conflict, it might be a way to alleviate the concern that one person has access to all the information and the other person does not. It is really important when you create an estate plan to not appoint people together that you already know don't get along. That's not a plan that most estate planning attorneys would recommend. In fact, you would almost invite litigation if you appointed two people together who just have never been able to work, harmoniously. So it might be better if in that case not to appoint individuals together. But we have found in certain family dynamics that giving access to information often can alleviate feelings of suspicion or of, just general mistrust by making sure that you have representation from all sides of your family in your estate planning documents. Again, to the extent feasible, considering your individual circumstances. And it's clear that every single client that we meet is going to have different considerations, which is why meeting with a qualified estate planning or estate litigation attorney is really crucial, because there may be factors that you have not even considered that a qualified lawyer would ask you about and help you strategize around. So each person's plan is very individualized, but there are some general rules that most estate planning attorneys will follow. So aside from communication and including parties from both sides, another way that we can try to avoid conflict, again, is to make sure the documents are done when you are in good health, when you have had opportunity to think about them, when you use attorneys. Let's say one of the biggest instances of mistrust usually comes when a client has a long-standing relationship with an attorney, maybe 10 years or more, and all of a sudden, as they're getting ill or they're losing capacity or just becoming older, someone takes them to see a brand new lawyer and all new documents are drafted. Those are the kinds of things that can create problems. So making sure your documents are done when you're healthy and well and clear-headed, and when you've had the opportunity to really think about them, review them, and have input, in how the documents are crafted, those are the most defensible plans. So if your plan ever needed to be defended, a lawyer who keeps an accurate, very robust record about your wishes and why you wanted the plan a specific way will be in a much better position to defend your choices if litigation ever occurred. And the other piece of that is to consider the use of what we would call irrevocable documents. And this is important for a number of reasons. An irrevocable document, for example, like an irrevocable trust, is a document where you might set up an estate plan and fund that plan during your lifetime in a way that it can reasonably not be altered to a great extent. Or just the creation of an irrevocable plan would be evidence that you intended for the assets to be distributed in a specific way and not to have a great deal of change on that distribution plan throughout your lifetime. And this could be important, especially if you want to make sure that your children from a previous relationship are provided for. Oftentimes, when you get remarried, or even if you don't remarry legally, but you give power of attorney to a companion, that person with a New York State, fully executed New York State power of attorney could actually move assets out of your name. So, for example, just leaving an account in 3 equal shares to my 3 children, thinking that that will mean that that account will be distributed at my death, doesn't always assure that that will happen. If that asset is transferred out of your name, let's say for Medicaid planning during your lifetime, that distribution pattern will not necessarily be honored unless it's carried over into the new account. So using irrevocable formats might also be a way of assuring that assets are held in a particular way and that your desires for your estate plan will remain intact. And again, that will be on a case by case basis, whether that's an appropriate vehicle for you to use in your particular circumstance. The other way that we plan, especially with estate litigation in mind, and this could be true whether you have a blended family or a traditional family and you plan to treat your children differently, is considering the use of no contest clauses in your will or in your trust. These clauses, and they go by different names, but I think they're commonly understood by clients to be clauses that say if Mary Jane objects to what I've given her in this will, she will lose the opportunity to take anything. And therefore, in hopes that that inclusion of that no contest clause will preclude a person from raising a challenge. So there are pros and cons to using no contest clauses in estate planning documents. And again, an experienced estate litigation or estate planning attorney can explain them in more detail. But just from a general perspective, using a no contest clause would mean that anyone who mounts a challenge to your will, and that by challenge, I mean file formal objections, either to a will or to a trust instrument, would, unless they could prove fraud, would be disinherited from receiving anything under your estate plan. And this can be a disincentive to challenging a will, especially when the person doesn't really have a good faith basis for bringing a challenge. Using a no contest clause is not a good option if you don't plan to leave a person something. And we can explain in further detail individually. But if you do plan to treat different children differently or unequally, and you're afraid that the person that you either leave less to or leave out altogether will challenge, you can use a no contest clause in an attempt to defer them or deter them from doing so. The only exception to this is you cannot disinherit your spouse, legally married spouse in New York. And that's something, again, that somebody can go over with you specifically. So the other most important thing to consider, other than what we've already discussed, communication, including members from both sides, making sure you use properly executed documents and no contest provisions, would be to use all available forms to evidence what you would want in your lifetime. So for example, in our advanced directives package at Littman Krooks, we include a form called nomination of guardian. And what that form does is it evidences for third parties that if you were to become incapacitated and if you were to need a guardian, that you have pre-selected somebody to serve in that role. And that's important because that can be very powerful evidence for a court when they are determining whether or not a guardian should be appointed, and if a guardian is appointed, who should that guardian be? And the court is bound by the statute actually to consider your preference. So if you now can no longer speak for yourself, but 10 years ago made a nomination of guardianship form and you nominated your spouse or you nominated your children over your spouse, that is very powerful evidence of how you would want the court to appoint individuals to take care of you throughout your lifetime. And so where those forms are available, they should be utilized. Another document that can be very helpful is a living will. So the living will is a companion document to a healthcare proxy, and it specifically directs end of life decision making. Oftentimes, if a spouse and children of a previous relationship are not on the same page, especially as it pertains to medical decision making, there can be conflict around what treatment options should be considered, whether life-saving measures should be taken. And creating a document called the living will can alleviate those concerns. So the living will is a document that we prepare as part of our advanced directives package that goes through certain decisions that you would want made on your behalf if you were unable to speak for yourself. And they are based on the concept that you are either at the end of life or you've had a progressive illness and this is the last set of decisions. And that usually pertains to artificial nutrition and hydration, the use of a respirator, whether you would want to be kept alive by those means or whether you would wish to pass away. It also has provisions for organ donation, very detailed provisions for organ donation, which can be helpful because if there is conflict between your partner and your children from a previous relationship, if a court needed to be involved, or even if a medical facility needed to be involved, your wishes in your living will would be a very powerful indicator of what you would want. And that should eliminate any gray area or any argument among the parties, which again, would be a really good tool to avoid potential for litigation. And last, other than using the available forms, the last recommendation that I would have is if you absolutely cannot find common ground, and you know this already, you cannot find common ground between your partner and your children, consider the use of third parties in your documents. So for example, power of attorney is not limited only to your spouse or your children. You can name literally anybody you desire in your power of attorney. It should be somebody you trust and that you have a working relationship with, but you can name more distant family member like a cousin. You could name your sibling. You could name your neighbor or a long-term friend if that's somebody that you had a relationship with in the past. So you don't have to be confined to your family. So if there's somebody who has a good relationship with both sides of your family, maybe a sibling or a cousin, and they can maybe bring reason to the equation, they would be a good choice. We also sometimes will recommend the use of more of an institutional person, like a bank or a corporate trustee. If, for example, you have funds that exceed a certain amount of money, every bank has a different threshold, but and if you're concerned about disagreements among your children, you can certainly use the services of a corporate trustee or a bank to perform the duty of being your executor, being your trustee, managing your money and making sure that distributions are made in accordance with your wishes. And this can also remove any type of conflict that exists between the parties so that you can be assured that to the extent possible that your estate plan will be respected. So again, there's no surefire way to prevent every single occurrence of conflict among families. But certainly at Littman Krooks, we handle a great deal of estate litigation and elder law litigation. And we do see a higher incidence of litigation among families where the children and the partner are not from the same relationship. And so we have found in the past that following some of these guidelines can alleviate those issues before they arise. So I see one question here. When do you appoint people from both sides? Right. So again, if you have a scenario where you have a good relationship between your partner or your new spouse and your children from your previous relationship, that is an ideal scenario where you would appoint someone from both sides. You can have co-power of attorney, you can name co-trustees. The only document where you can't name two people at one time would be your healthcare proxy. So that document, you need to name a primary and a backup. But every other document, there is room to name parties to work together. Again, it should be parties who reasonably can work together. If you're already in a scenario where you know that your children and your partner or your spouse don't get along, appointing them together is not ideal and probably is not recommended. But if you feel that they could reasonably work together, it would give each person access to information, to bank statements, et cetera, and could guarantee that they would necessarily both be informed, and that, usually the availability of information will have the effect of decreasing the likelihood of litigation or conflict in the future. Does anybody have any other questions? I would like to say to the participants that our website has a great deal of information about blended families. Our Littman Krooks blog has topics of recent relevance, including the blended family discussion. Additionally, our Lunch with Littman Krooks web series or Zoom series will continue later this spring. And so you can be on the lookout for our email newsletter, which would contain information about our upcoming programming. And also, again, all of our previously recorded lunch and learns are available on our YouTube channel. And you can see information on topics such as Medicaid planning, estate administration, the pitfalls of using an online will program. There's lots of great material on our website, even into the special education area in our practice. So we look forward to serving you. And if you have any questions, feel free to give our office a call and set up a consultation.